Hey there, students. Tom Ritchie here for the night before the AP Government Exam 2020. So the exam is going to be tomorrow, I believe, at 4 o'clock, if I'm not mistaken, 4 o'clock Eastern, that is. And we're going to have a review session tonight. And I'm going to also be live tomorrow at 2 p.m. Eastern. Okay, so 2 p.m. Eastern, I will be live for just one last review before the government exam. So we have got AP Government and Politics going on tonight. Now, let me just go ahead and note that if you want to get a free practice exam, let's go visit my friends at Marco Learning. I'm going to put this in the description, okay? So visit Marco Learning, okay, for a free practice exam, okay? Subscribe to Marco Learning's YouTube channel. To see videos of me demonstrate, of me giving examples of correct answers. Okay, so as far as that goes, make sure to visit Marco Learning's YouTube channel. If you'll refresh this, if you're on YouTube, I've got a link to a free practice test. Okay, so Marco Learning has put out a free practice test. And so that's something that'll be available at marcolearning.com, and you can say free practice test. So make sure that that's something that you're going to do. If you want to do one last practice test, I'm going to put that out there. All right, so y'all want to put a phrase on there? That would be really funny, wouldn't it? If y'all just wrote on your exam tomorrow, Baby Yoda. I don't know if we've got enough Gov people in here to make that much of an impact, but I do have now my Baby Yoda mask that I'm very proud of. I would teach in it, but I feel like it kind of muffles my voice. But isn't he so cute? All right. So as far as that goes, that would be kind of funny, wouldn't it? Now, those of you who are on YouTube, you are certainly welcome to watch on YouTube. Primarily, I'm taking questions here in Crowdcast. So I'm also going to put that in the YouTube description. I'll go ahead and put it in the chat. So, so we're going to note here, those of you in the YouTube, continue to chat, but go to, to ask questions. Okay, so I'm taking questions through my Crowdcast course. And so if you go over there, I've got the description updated here. All right, so as far as that goes, we're going to go ahead. Yeah, I'm wondering, do y'all know, August, that's a good question. Does this thing have a strike through? Like, does the College Board simulation have a strike through function? That's one thing that I'm curious about, because previously when we wrote something on the exam to show solidarity, we would strike through it with an actual pen. Is there a strike through function? That's interesting. Okay, so that's something that we want to note here. So I'm going to start answering questions in just a second, but I do want everybody to go to .com, where they have free practice tests for 10 different subjects. Okay, so the way to find this, when you go to marcolearning.com, free resources, practice test, and you see here where we've got 10 different practice exams. Okay, so there are probably some other AP exams that you're taking. Marco Learning has 10 different practice exams that you can download for free. So be sure to take advantage of that resource. I've got that in the description of this video. All right, so going from there, let's go ahead and start taking questions. All right, so going with that, can I explain selective incorporation? Okay, so Faith, I would be glad to explain selective incorporation. And in fact, I have something here that I want to get into here. Let me give y'all a sample item that I've actually come up with, a sample argument essay. So we're going to go ahead and let's see. I'm going to find something here that I made on selective incorporation. Okay, so let me just go ahead and give y'all that. And let's see, I'm going to go ahead and put that in, those of you who are here live in the chat. And actually, I'll go ahead and put that into the Crowdcast chat. But then on YouTube, I'll go ahead and put this in the video description as well. Okay, so let's go ahead. I'm going to put this, share this with those of you on Crowdcast in the chat. and then we're going to go to YouTube. Let's see. So Selective Incorporation, argument, essay, prompt. Okay, so I'm going to note here. Okay. And you know what? We may actually do that with some of this tomorrow. Okay. So just keep in mind that these exam items that I'm sharing with y'all, what I'll plan to do tomorrow. Hey there, Vivian. Nice to hear from you here. What do y'all think about tomorrow? What I can do here is, tomorrow I'll actually work through some samples. What do y'all think about that? Y'all let me know in the chat, and I'll go ahead and put a poll up in Crowdcast here. Should I work on sample items, okay, tomorrow? Okay, so yes, please, or no thanks. Okay, so let me just note here, I think tonight we'll work on Q&A, and then tomorrow we'll actually do some sample items. What do y'all think about that? And then we can also get into some notes here as well. Okay, so what we're going to be doing here, and then let me go ahead, one last thing to kind of set up is we are going to go into into Google Docs and make sure that we've got a Google document that we can, note here. Let's see, actually, you know what? Let's see. Let me just note something here. Let's see. Going to message and see if I can find some things here. All right, so let's go ahead and answer the first question that we've got here on selective incorporation. So basically, the Bill of Rights, what we want to understand is there's a Supreme Court case from the 1830s called Barron versus Baltimore. Now, you don't necessarily have to know that case. It might not hurt, but it's not one of your 15, but the court case is called Barron versus Baltimore. And Barron versus Baltimore was a case, it was a martial court case that oddly, which martial court tends to get a lot of attention for siding with the federal government. But in this case, the Supreme Court said before this, a few decades before the Civil War, that the Bill of Rights only applies to the federal government, that the framers of the Constitution and the James Madison, when he wrote the Bill of Rights, it went through Congress, it went through the states, then it was ratified by the states, that this was only intended to apply to the federal government. One thing we want to note is that some states, such as Connecticut and Massachusetts, continued to have state-sponsored churches after the American Revolution. So even though the First Amendment says that Congress shall make no law respecting the establishment of religion, there was nothing in the Bill of Rights as it was originally intended to say that the states could not have their own established churches. So Massachusetts and Connecticut didn't get rid of their established churches until the 1830s. So we see that the Bill of Rights did not initially apply to the states. Now we get to the 14th Amendment. Okay, so when we get to the 14th Amendment, what we want to think about here with the 14th Amendment is we've got first of all, that everyone's a citizen of the United States. The 14th Amendment has the birthright citizenship clause that if you were born here and you're subject to the laws of this country, you are a citizen of the United States. And so as far as that goes, that's first. 14th Amendment, you're a citizen of the United States. Second of all, that you have a right to the equal protection of the laws. You have a right to due process. I don't know if y'all seen my latest video about cheating on the exams. It looks like Trevor Packer said, oh, we've caught a cheating ring and we've already invalidated their scores. And it's like, well, wait, last time I checked, the exam has not happened yet. So if you haven't watched that video, go show it some love. But as far as that goes, when we're thinking about this, that the whole idea of due process, you would think that if somebody's going to be in a situation where they're going to be penalized for cheating, that they were actually cheating, that they weren't just planning to cheat. And so when we think about due process, in order for somebody to become a criminal, okay, they have to have received due process of law. So we've got the equal protection of laws and we've got due process of law that are guaranteed by the 14th Amendment. Well, what happens here is the 14th Amendment, rather than like if we think about the First Amendment, Congress shall make no law, the 14th Amendment says no state shall. Okay, so no state shall make a law that, as far as this goes in the privileges and immunities clause. Let me go ahead and put the 14th Amendment up here for everybody. Okay, so the 14th Amendment to the Constitution. Okay, so let's go ahead and pull that up, and I will go ahead and display that here on my screen. Let's see. All right, so I'm going to go ahead and share here. So we want to note the 14th Amendment. Okay, so all persons born or naturalized in the United States, subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. Note these words: no state shall. Okay, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, when we think about that, the due process clause, let's think about Gideon versus Wainwright, that the state of Florida had a law, in their laws, it said that the only people who would have an attorney provided to them for their trial are people who are up for capital punishment. If you've committed a capital offense, the state of Florida would provide you with an attorney. Now, note that I've got a video on Gideon versus Wainwright available on my channel. There are also some court case videos available on Marco Learning's YouTube channel as well. So you definitely want to check out Marco Learning's YouTube channel. And so with that, what we want to understand is that no state shall nor deny any person within its jurisdiction the equal protection of the law. So the equal protection clause. Now, what we see here is that the Supreme Court decided in the 20th century, they began saying that, look, if we're going to have equal protection of the laws, and no state shall make or enforce any law which will deprive someone of due process or deny equal protection of the laws, then what we're going to need to do here is we're going to need to incorporate the 14th Amendment to apply, the Bill of Rights to the states. Now, the incorporation doctrine says that through the 14th Amendment, the Bill of Rights is applied to the states, but it's applied selectively, okay? So selective incorporation means that, the Supreme Court basically decides what rights in the Bill of Rights have been incorporated. Now, there are just a handful of rights in the Bill of Rights that have not been incorporated. Just a handful, but the Supreme Court has kind of done these one by one. The most recent example of selective incorporation, or one of the most recent, but certainly the most recent, your 15 cases, is Mcdonald versus Chicago. Now, Mcdonald versus Chicago is where the Supreme Court said that the Second Amendment does not just apply to the federal government. The Second Amendment applies to state and local governments as well. And so what we're dealing with here is, the due process clause. When you're thinking about this, the Second Amendment and having your rights taken away without due process. Okay, so as far as when we're looking at, at McDonald, that somebody was in Chicago, that somebody's living in Chicago, and the laws of the city of Chicago are basically making it so. So we've got here the due process clause, or the privileges or immunities clause of the 14th Amendment. Now, the privileges or immunities clause typically isn't going to come up. I think that the most important ones that you're going to look at are due process and also the equal protection clause. So the equal protection clause is Brown v. Board. The due process clause is Mcdonald versus Chicago. And so, basically that, the court ruled that the city of Chicago took away a constitutional right from McDonald by making it so, almost impossibly difficult for McDonald to have a firearm to protect his home, as had been decided in a previous decision, DC versus Heller, that said that the Second Amendment protects an individual right. So selective incorporation happens every time the Supreme Court says that here is a right that not only applies to the federal government, but it applies to the states as well. Okay. Now, as far as that goes, you can also look at Engel versus Vitale is an incorporation of the First Amendment. Okay. So the First Amendment, the Establishment Clause. Now, the Establishment Clause says that Congress shall make no law respecting the establishment of religion or preventing the free exercise thereof. Now, the Establishment Clause, that is where you've got Engel versus Vitale. Wisconsin versus Yoder is the free exercise clause. Okay, so in Engel versus Vitale, the Supreme Court selectively incorporated, in terms of the Establishment Clause, said that the state of New York, by reading a prayer over the loudspeaker in a public school, was violating the First Amendment. Now, without that kind of incorporation, states can be free to, if a state wants to promote religion, a state can promote religion. But because of Engel versus Vitale, a state or state authorities, they cannot promote any religion. Now, in the case of Engel versus Vitale, it is a case where what we're seeing here is that they're promoting, they're not necessarily even promoting the Christian religion. Engel versus Vitale is a decision. I was looking at the popularity of Supreme Court decisions. Only 30% of Americans at the time agreed with Engel versus Vitale. But of course, in a republic, we're a democratic republic, not a democracy. And when you're looking at that, what you're seeing is that there are individual rights that are protected. And so then when we look at Wisconsin versus Yoder, now that is the free exercise clause of the First Amendment. So this Amish family decided that they did not want to send that, it's against, the Amish custom to send a child to school past the 8th grade, because there's nothing in the Amish way of life that is contingent on someone having more than an 8th grade education. And the Supreme Court said that because the Yoders, their decision here to take their children out of school in the 8th grade was rooted in their religion, then that is protected, that the state of Wisconsin could not keep the Yoders from practicing their religion freely. Now, there's another thing, too, that they said we have to look at the cost-benefit analysis. The law in Wisconsin, basically, it only said that you only have to go to school through like age 16. And so the Supreme Court, when considering that, okay, Wisconsin gang out there, Colin. So the Supreme Court had to consider here that what are the benefits of a student going to school for 2 more years? So, maybe they would have considered some things if, Wisconsin was mandating that they stay and get a diploma. But it was just like, look, you're violating these people's religious beliefs, and there is really no payoff, no social payoff for it. So remember that Wisconsin versus Yoder can be used for the free exercise clause. And remember that while there is no Supreme Court comparison case, we could very well see Supreme Court cases used as evidence for the argument essay or for the concept application. Now, one thing that we want to note here is when we're looking at the argument essay, you see 3 foundational documents that are listed there. One of your pieces of evidence is going to have to come from one of those 3 foundational documents. One piece of evidence will have to come from there. Now, the other piece of evidence can come from another foundational document. It could come from one of the 3. You can use 2 out of the 3. Now, it could also come from another foundational document that's not listed, or, wait for it, it can also come from another, just something so a court case. So you can use a court case as evidence to support your argument in the argument essay. You can use a law, so for example, if you said the War Powers Resolution, you could bring that in. So you can bring a piece of legislation, really anything that Now, I think that between the court cases and, when we think about between the court cases and the foundational documents, I think you're pretty much covered there, and you've got plenty of evidence that you can use. But I think it's important to note that your second piece of evidence can be a court case. Okay, there is nothing stopping you from using these court cases and what you've learned in those court cases. So with that, we want to keep that in mind. We've explained selective incorporation. Okay, so yeah, Matthew, what I would say here, you're asking, should we worry about Supreme Court cases or focus solely on the foundational documents? Now, I wouldn't tell you to worry about Supreme Court cases, but if there are Supreme Court cases that you could use, then you should use them. Okay, not that you necessarily have to use one. Now, the foundational documents, I think, are non-negotiable. Given that the argument essay is, on the foundational documents, that's a non-negotiable. But court cases can still be helpful. Okay, so let's think about this. I would say, let me do a little poll here. I would say that I know at least 3 of the 15 court cases well. Okay, me or not me. Okay, so let's see what's going on here. Okay, so let's see that if any of you would say that I know at least like 3 of them well, to the point where I think that I could, I could probably use those as evidence, which a lot of y'all are coming from, AP US history previously. So when you think about like Marbury v. Madison, or Marbury v. Madison, or the or Mcculloch versus Maryland. Okay, Brown v. Board. That's one that is one of your, one of your cases. Would be an AP US history. It won't be on the exam this year for APUSH, but it's on the exam most years. And so all of you are saying that at least some of these Supreme Court cases, knowing them well, meaning that you could use these as evidence, convincingly as evidence. So I would say here that yes. Now I would focus, what I would do is I would focus on like a handful of these Supreme Court cases. Now what I do, my advice is to, in this format, because we don't have the Supreme Court comparison, I would zero in on a few of them to know really well and think about using them as evidence for almost anything. Like I've almost got a game with myself that like no matter what the prompt on the argumentative essay, I can bring in, I've got a way, like if you thought about, here are my 3, and I can use all, I can use one of these 3 to answer just about anything. I have got prompts that I tend to try to use Mcdonald versus Chicago, and I'll show how I can use Mcdonald versus Chicago in this prompt for both the pro and the con. And so that's something like the one on selective incorporation, for example. That you can use really any of the court cases that deal with selective incorporation, and there are arguments for Mcdonald and against Mcdonald. So first of all, when we think about like Mcdonald versus Chicago, if you are if you're in favor of gun rights, then you are going to say that Mcdonald's constitutional rights have been protected by an interested majority, or an interested, a faction. Okay, when we think about this, a faction can very easily get in control of a state or local government, but it is more difficult on a federal level. So basically, you could say that Mcdonald's rights were being violated because of a faction controlling the government of Chicago. So that brings us Mcdonald versus Chicago and Federalist 10. Now, the other side of that, if you're for, for stricter gun control measures, or if you're against the civilian ownership of firearms, or at least you think that should be up to a local community, you could say that, use Brutus #1 to say that the people of the states should be able to decide for themselves what rights that they have. So for example, if you think about like Wyoming and New Jersey, the state with the smallest population and the state that's most densely populated, might they have different views of the second, of gun rights, okay, and the Second Amendment? Very well, they very well would. When you think about, you ask people in New York City how they feel about, people having guns, or you go into rural Kansas, you're going to get different answers. So remember with these court cases, there are going to be like pros and cons here that you're going to see. Now, Yeah, so Nicole, yes, when it comes to the argument essay, what I recommend, the format I recommend, and I'll do this during tomorrow's broadcast, 2 p.m. Eastern. What I'm going to recommend here is that we think in terms of having so 2 points, basically a thesis that has 2 lines of reasoning to support it. And so the thesis has 2 lines of reasoning to support it. And then, each of those lines of reasoning is the subject of a body paragraph. If you go to Marco Learning's YouTube channel, let me actually go in here and find this. Okay, so youtube.com/Marco Learning. I would definitely be subscribed to this channel. This is a great thing to note here. Now, also the latest video on Marco Learning's channel, John is explaining kind of once and for all, like what is open notes, what is cheating. Okay, so there are a lot of great videos on here as far as so if you're thinking about that, 3 traps to avoid on the open note exams. Okay, cheating on the 2020 exams. So this is something that as we're seeing this, we need to think about getting ready for your at-home AP exam. So I would say that Marco Learning is a great, that would be the best decision you made today, to subscribe to Marco Learning and to get the updates that they're going to be doing here. Okay, so we want to make sure that y'all know about that. Now, when we see the, let's see what we've got as far as playlist. Now, we don't have we actually do have an AP US government, but it might just have 1 video on. Okay, now Baker versus Carr, that Supreme Court decision, is on Marco Learning's channel. Now, if we go into videos, we are, what I would just search, Marco Learning AP Government. Okay, so Marco Learning AP Government. Okay, so what we've got here, we've got AP Government to 2020 practice test review. Okay, so this is where I did an argument essay on the presidency. Okay, so that is available for you there, which that may be the one that I do tomorrow as well, but we'll see. So the concept application question, I did this on Marco Learning's channel before. So what we want to note here is that there's tons of stuff, a lot of stuff on that channel. I don't know, tons. Do we measure it? Do videos really even weigh anything? But that would be important, important reference for you there. All right, so going from there, so that is a great question, Kellen, what is the difference between the effects of separation of powers and checks and balances? This is this is something that's got a bit of a nuance here, okay? Because they're both principles that are dealing with the 3 branches of government. And so with that, hey there, Nico. And so going with this, what is the difference? Now, separation of powers just means that the powers of each branch are separate. So we have legislative, executive, and judicial. All right. So the legislative branch makes the laws, the executive branch enforces the laws, and the judicial branch judges the laws when there are disputes concerning them. So that's, when we look at the 3 branches of government, legislative, executive, judicial, that's separation of powers. Now, checks and balances, this is how each branch has a check on the powers of the other branch. So the branches are not necessarily fully sovereign in their own sphere. So when we think about checks, so for example, the most visible check would be the president's veto. That is a check on the legislative process, and it is almost impossible, not impossible, but it's very, very difficult to get past a presidential veto. So a presidential veto, it is very difficult to get over that. And that is the president is able to intervene in the legislative process. In fact, one of the president's kind of unofficial titles is chief legislator. That the president is the chief legislator of the United States. Some people refer to the president as the 3rd House of Congress, okay? The 3rd House of Congress, that the president, because the president basically has to be okay with things that are happening. The president will occasionally make what's called a veto threat. And what happens if the president threatens to veto a piece of legislation that's being debated by Congress? It is something that in a lot of cases will, slow down the momentum of a bill or possibly stop it in its tracks. because basically it's like, well, we're wasting our time here if the president's going to veto it, unless the Congress is controlled, both houses are controlled by the other party, and they're trying to make a point. Okay, sometimes they will do that. Vetoes are occasionally overridden, but not much. Now, the oversight power of the Congress, that's something where we see that congressional oversight, basically the executive branch has Congress constantly looking over its shoulder. So that's something that is a check, like when the Congress can say, we want this person to come testify or something like that. And then we look at impeachment. That is a check that the legislative has over both the executive and the judicial branches, that officers of the government can be removed from office or tried, and to see if they'd be removed from office. Now, some federal judges have been successfully removed from office by the impeachment process. Now, for president, it's 0 for 3. No president has been removed. Now, remember, Richard Nixon resigned to avoid being removed from office through the impeachment process. But that's a check. Now, another thing, when you think about the judiciary, a check that they have is that they serve on good behavior, okay, which is basically for life. Okay, they serve on good behavior, which means that they serve until they retire, they die, or they are removed by the impeachment process. Now, a check on the judiciary is the confirmation process. Now, you should have a pen and paper. Okay, so you should have a pen and paper in front of you right now. Remember the judicial confirmation process. The president nominates, okay? The president nominates someone to the Supreme Court. The Senate, now this is a difference between the Senate and the House. I would watch my video tonight on the Senate and the House. I've got a video comparing the powers of the Senate and the House. So y'all want to make sure that y'all are watching those videos on the Senate and the House. So with that, the Senate gets to confirm justices. Okay, so when it comes down to it, Supreme Court justices or any federal judge, every federal judge serves on good behavior, which is, remember, you retire, you die, or you're removed through the impeachment process. Every judge serves on good behavior, and every judge, is confirmed by the U.S. Senate. Has to be nominated by the president and confirmed by the U.S. Senate. So that's something that you want to make sure of, that you understand the difference between the powers of the Senate and the powers of the House. Can I explain Citizens United in depth? Ashley, I cannot, because that is actually something that has been taken off the exam. Citizens United is the one Supreme Court case that is in units 4 or 5, like I believe it's in unit 5 with the campaign finance. So you will not have to understand Citizens United for the exam. Now, if you understand the free speech part of Citizens United and you wanted to use that on your argument essay tomorrow, that would be a possibility. But there is nothing on the exam that is going to require you to know about Citizens United. So I think that that's something that you should note there. All right. So as far as that goes, let's go ahead and check out the next question. So this is fine. Sometimes, all the stuff about like campaigns and elections. Now, let's see, Nathalie. You do not have to have a counter argument. Okay, so as far as the AP Government Argument Essay Rubric, okay, so the AP Government Argument Essay Rubric. All right, so I'm going to give y'all a link to my page on the AP Government Argument Essay, and why not go over the rubric? Okay, Ashley, that is a nice thing to hear, isn't it? When there's something that you're scared of being on the exam and you find out, you know what, it's not going to be on the exam this year. And so as far as that goes, we've got this here. This is a link to my page on the argument essay. Okay, so we've got a rubric here that I will go over now. Okay, just so we're clear, I think this is a good thing the night before the exam to make sure that we are clear about what is going to be expected on this exam. Okay, so going from there, let's have a look. So we see here a thesis or claim, okay, articulates a defensible claim or thesis that responds to the prompt and establishes a line of reasoning. Now, a line of reasoning is very important here because you can't just say that such and such is beneficial. Okay, you can't just say that such and such is beneficial. You have to say why it is beneficial. So there has to be, typically when I talk about thesis writing, I think in terms of how and or why. Okay, so I'm thinking in terms of how and or why. It's got to explain some things here. So with that, let's go ahead and make a note here of what we do from there. Now, there are 7 points total. Okay, now note here, the opposing or alternate perspective is not on this year's exam. Okay, so that's typically on the rubric. It's not going to be on this year's exam. And so then we look here. So we had our thesis statement, and then we've got up to 2 points that are not dependent on a thesis. Okay, these are the only 2 points that are not dependent on a thesis. These 2 points that say that you are bringing in 2 pieces of evidence that are relevant to the topic of the prompt. Now, it does not have to be one of the foundational documents that's noted there. It does not have to be a foundational document at all. It does not have to be a Supreme Court case. Now, I would think that you should have enough by using the foundational documents in the Supreme Court case. But what I'm noting here is this can be any 2 pieces of evidence that are relevant to the question. Now, going from there, if there's no thesis, you can only get 2 out of 7 points. All right, so that's all you can do. So make sure that you've got a clear thesis. Okay, so there must be a thesis in order to get these other 4 points. So what you're doing here is you are using at least one piece of specific evidence supports the claim or thesis. So for 2 points, I can just write down 2 things. I can say, hey, James Madison said in Federalist 10 that, factions are part of small republics, that factions can take over states, and the Constitution being ratified will limit the influence of political factions. Okay, so that's something that you didn't have to relate that to a thesis. Now, the thing is that when we're looking at this here, we have to think in terms of it has to be tied to a thesis. Now, remember, tomorrow I will go into how to answer these things. Okay, I will go into how to tackle these. And so we'll see what is an example of what to do, what not to do. And so going from there, we see 1 point here. Now, this is where to get the second point in this group, at least one must come from one of the foundational documents in the prompt. So what you need to plan to do is, out of your 2 pieces of evidence, one of them needs to be one of the 3 foundational documents that's listed in the prompt. Okay, that is something that's non-negotiable. The second piece of evidence can come from anywhere else. I would think first about foundational documents. I would think second about Supreme Court cases, and then if there are congressional laws or something like that that you can bring up, I think that could work. That could work as well. But one strategy that's probably pretty decent is to use 2 of the 3 that are listed there. Just go ahead and use both of your pieces of evidence there. Now, another thing that, because you've got plenty of time here, okay, so one thing about this exam is you have plenty of time on the AP government exam. It's not like the histories where you're going to be running out of time. You've really got plenty of time here, and I'm going to show you a nice little graphic that my friends at Marco Learning have come up with here, a timing guide for the AP U.S. government exam. So let's go ahead and take a look at this time. Oh, I've already got it up. Okay. So as far as that goes, a timing guide. So what we're looking at here is 30 minutes to log in. So remember, you want to be logged in 30 minutes before the exam. I will make sure, okay, that 30 minutes, 30 minutes before the exam, I'm finished broadcasting. Okay. I will cut off my broadcast tomorrow 30 minutes before the exam starts to allow y'all to log in. The argument essay, you've got 25 minutes plus 5 minutes to upload. At 25 minutes, a red light will start blinking, okay? and telling you it is time for you to upload your essay. Now, I found that it really doesn't take 25 minutes to write this essay. You should be able to do it in well under 25 minutes. So, and then you've got 15 minutes for the concept application, A, B, and C, and then 5 minutes to upload that. So going from there, and you know what, I'm actually going to, post. Let's go ahead and note here. I'm going to post. I'm going to share this this timing thing here for Marco from Marco Learning. Okay, so I'm going to go ahead and note this. Let's see. So the AP US government exam, the timing guide. So we see here, I'm going to go ahead and put that on my Instagram account so that you'll have this timing guide available to you. Okay, so thanks, Mark. I'm at Tom Ritchie on Instagram. Okay, so for providing us with a clear time, with a clear timing guide for the AP Gov exam. Okay, so with that, so we've got here, best of luck to everyone on taking this exam on Monday. Okay, so as far as that goes, we're going to go ahead and tag our friends, Marco Learning. I am at Tom Ritchie on Instagram, and of course, my friends at Marco Learning. Okay, so let's make sure that y'all are showing them some love as well. Just so much great test prep, and I'm really glad to be working with them this year and looking forward to continuing to work with them next year. And so that's now posted on my Instagram. If anybody follows me, I'm going to give you some shout outs. And it's going to be, it's going to be great. All right. So as far as that goes, I think we're good there. All right. So going from there, let's go ahead here and okay, yeah. So we need to finish up looking at that thing. Okay. So I wanted to make sure we're thinking about your time. Okay. So we're thinking time, and so now let's go ahead and go in here and let's see what we got here. Okay, so we look here. So you want to plan on one of those pieces of evidence supporting a thesis. Now, it just needs to support a thesis, okay, in terms of, it just needs to support a thesis when we're thinking about, it doesn't necessarily, like the thesis is there. The reader can kind of see for these 2 points, they're kind of bonus points if there's some kind of connection to the thesis. So if there's a connection between the evidence used and the thesis statement, then that's going to get you those additional points there. But then reasoning, this is where you are going to have to know. Thank you very much, Simon, for the Instagram follow. Appreciate that. Carly, appreciate that Instagram follow. And then Jay Bowler 84. Thank y'all very much for your support there. And so with this, you actually have to explain how or why one or two pieces of evidence support the claim. So this is where you're going to have to make sure that this is brought back to your thesis, that it's clear that these don't only support a thesis, but these are things that are, that you're explaining how they support the thesis. So going from there, that is the rubric for the argument essay. And so what I recommend is a thesis statement that's got 2 prongs on it, like basically 2 lines of reasoning. Each body paragraph is dedicated to one of those lines of reasoning. Okay, so that's something that is important. Now, again, if you want to see me do an argument essay, you can go to Marco Learning's YouTube channel and you can see me do an argumentative essay. Yeah, there's really nothing. What I do here as far as do we need a conclusion, it's not so much a concluding paragraph. I would restate my thesis. What I would recommend is you write your thesis, 2 body paragraphs, and then restate your thesis. Now, one thing that I would note here as well, okay, is that the AP government exam uses what's called positive scoring. They score what you have, not what you got wrong. It's not a bad idea to perhaps bring in a 4th piece of evidence. I mean, not a 3rd piece of evidence. if you can do it easily, okay? And I'll show you that tomorrow. I don't think it's a bad idea to use like 3 pieces of evidence, maybe 4 if you've got time. Now, what you don't want to do is short something, okay? So that's why I don't think I'd go for 4, but if you want to throw in a 3rd piece of evidence, if you can actually do it thoroughly, I don't think that that's a, that's a bad idea. Let me see something here. Let me note here, just kind of in the crowdcast to see, has your teacher recommended using a 3rd as insurance? Okay, basically insurance, like just making sure that if you got one wrong, you got a 3rd one. Okay, so as far as that, I'm just kind of curious if there are any other teachers that are recommending that as a strategy. Now, that's something, if you're able to do it without running out of time and without shorting anything else, but if it can go in there seamlessly, I don't see a problem with bringing in a 3rd piece of evidence if you've got it. Okay, so we do see some teachers are saying that as a strategy, because remember that the AP government readers, they're not counting off for what you got wrong. They're giving you credit for what you got right. And so there is nothing that is stopping you from using a 3rd piece of evidence. Okay, so I see it looks like, over a 1/3 of teachers are recommending, about 40% of teachers from the looks of it are recommending adding a 3rd piece of evidence, just to make sure that, in case, because it's very easy to misunderstand something. It's very easy to misunderstand something, and you don't want to be in that situation. Thank you, Mike Sweeney and let's see, Katarina. We've got Katarina and Rusty Freight Car. Thank y'all so much for the follows there on Instagram and for the support. Can it come from the same document? Okay, so what I would do here, yes. So Nicole, when we're thinking about, you're asking if one of the sources is the Constitution. Okay, so what you're thinking about, if one of your sources is the Constitution, can both pieces of evidence come from the same document? I would say, Nicole, it would be better to bring in a different source. Like if the Constitution is used there. Now, if it says the 14th Amendment or the Bill of Rights or Article 3 of the Constitution, it may be that you could use another article of the Constitution, but just to be safe, I would use another foundational document. Now, when they write these prompts, what we see that what they're doing when they write these prompts is they're putting plenty of room to argue. So when they write these prompts, they're thinking, you can use several foundational documents. Okay, so you can use several, they're making it to where there are lots of options. They're not, this isn't like a thing where it's like, okay, I'm gonna turn my light down just a little bit. I think that I'm just looking a little shiny. My natural light's going away as the sun is going down. So let me go ahead and put that down a little bit here, so I'm not looking quite so shiny. All right, so I think that's a little better. Yeah, so I would use distinct documents, because there's so much evidence that you can use. And again, these questions are all written to where you can use several foundational documents there. So I think that is important. Now, due process. Okay, so Faith, you're asking about due process. Now, I was talking earlier about Trevor Packer's tweet. I've got a video about this where Trevor Packer says, basically, we have invalidated the scores of a group of people that was planning to cheat. Okay, now here's the thing: the College Board, if they really did that, a lot of people are thinking that it's fake, but that they're not really serious. But as far as that goes, due process, it's like due process means, was there a trial, for example? Now, not just was there a trial, but did you have an attorney? So when you think about what's going on with, like, Clarence Gideon versus Wainwright, that was, he was found guilty by the Supreme Court's ruling without due process of law, that he did not get an attorney provided to him. So he had to go to court without legal advice. And so for a man who's not educated to have to go to court without receiving legal advice, that is not according to the Supreme Court due process. Miranda versus Arizona, which is not one of your 15, but Miranda versus Arizona, the guy basically confessed to a heinous crime, and his confession was thrown out by the Supreme Court because he was not read his rights. Okay, so as far as that goes, for some reason, I tend to forget whether Miranda was a rapist or a murderer, and it just always eludes me. But let's see. Okay, so I tell you, I've got this super sensitive mouse that's been giving me some trouble. But as far as that goes, so Miranda. Okay. Yeah. Okay. Yeah. Kidnapping and rape. Okay. So so basically you've got this, this violent criminal, who, because he wasn't read his rights, he walked. He didn't get due process according to the Supreme Court. Now, Miranda versus Arizona was again, not one of your 15. Now, one thing to think about here, check this out. Can you use a court case? Can you use any Supreme Court case to support your argument? Let's think about that here, okay? So Miranda versus Arizona, 1, 2, 3. Yeah, it was 5-4. So here's the thing. Let's see what y'all are thinking about this for the argument essay. Okay, so for the argument essay, are you limited to only the 15 Supreme Court cases in the course and exam description? Okay, so let's think about this. Your 15 Supreme Court cases, is it only those 15? So let's think about this. And so far, so good. You are not limited. It is only the Supreme Court comparison question that says that, we're going to go from one of these 15. But the argument essay, you can use Miranda versus Arizona, Texas versus Johnson, Plessy v. Ferguson. There are several Supreme Court decisions that you may be familiar with to some extent. Okay, so that's something that if you're familiar with it, you're welcome to use it. You are not limited to the 15 Supreme Court cases. Now, that doesn't mean that you need to learn new Supreme Court cases or something like that. Okay, that would be silly the night before the exam. But if there's a court case that that you are familiar with, that you know what you're talking about, then you can use that. It doesn't have to be one of the 15. So that's something that I think is important to note here, that, one of the 15. So we see here David use more documents. They would talk about the Constitution. So as far as that goes, David is saying here that he does get students typically to use more documents. Okay, so more than 2 documents, that is a totally acceptable strategy, that using more than 2. So with that, so John, the College Board was just testing everybody on due process. Okay, the College Board allegedly denied. Of course, here's allegedly, they're alleging it. So that's what what is interesting here, that they are alleging this about themselves. Okay, so yeah, that's exactly what I was thinking. CMSA push. He's got a GIF. We see here he's got a GIF where he's got the movie Minority Report. Okay, so that's on my Twitter at Tom Ritchie, on the Department of Pre-Crime, where people are being charged before the crime has been committed. So basically what we're seeing there in the movie Minority Report with Tom Cruise, that is a society where people are being arrested before the crime is committed, because they've got these these people that can basically see this person's about to commit a crime. And so then the person can be arrested before the crime is committed. Okay, so as far as that goes, let's go ahead and get into question is already posted. Okay, so going from that. Okay, so Miriam, the federal bureaucracy. Okay, so when we think about the bureaucracy, these are the people that work in the executive branch that have protected jobs. Their jobs are protected by civil service. Okay, so these are people whose jobs are protected by civil service. And, so because of that, when we call people bureaucrats, these are people who are career government workers. And what's interesting here, which any of y'all who follow me on Twitter, y'all hear me incessantly griping about, I probably use another word, but we're in a teaching capacity. It's just griping all the time about my neighborhood pool being closed. Okay, so what's happened here is the governor of South Carolina, or the dictator of South Carolina, whatever I'm calling him today, he said that because of the coronavirus, then all public pools are going to close. Now, the public pool in my, or no, it's not a public pool. I'm hearing this too much, but the pool in my neighborhood, according to DHEC, the State Department of Health and Environmental Quality, they have said these are going to be classified as public pools. So the governor of South Carolina did not say neighborhood pools will be closed. Like, you go to my neighborhood pool, it says private pool, residents and their guests only. It's not a pool that is open to the public. And so the governor ordered the closure of all public pools. And so what you see here is it's bureaucrats who decided to interpret the governor's order to say that all, basically any pool that's not a residential pool is going to be defined as a public pool. So what we see here is sometimes we could look at the bureaucracy as the fourth branch of government. Okay, so when we think about this, the fourth branch, because a lot of times it's the bureaucrats who are going to make the decision that they can decide. Like, think about this: when somebody gets pulled over, the police officer pulls them over. Now, note here that typically people don't get pulled over for going 2 miles over the speed limit. So the speed limit is this, but the police will pull you over for going this. That is bureaucratic, like, discretion. So sometimes bureaucrats decide that they are going to either strictly enforce a law or they are going to loosely enforce it. So the bureaucrats are the ones who are making the day-to-day decisions of government, as far as this is how the laws as they're written are going to be enforced. So Governor McMaster didn't say close the neighborhood pools. DHEC, which is a state agency, decided that neighborhood pools will be defined as public pools, whether they're open to the public or not. And so, my neighbor was talking about he's having to watch somebody clean our neighborhood pool, and we can't even go in there. That is bureaucratic discretion, okay, where we see that bureaucrats make those things here. Now, Federalist 70, actually, I would say that Federalist 70, if I were going to make that call there on Federalist 70, I would say that Federalist 70 in some ways maybe would be against a permanent bureaucracy, because, I think when you think about Federalist 70, the key word being energy, this idea of a unitary executive, that when the Constitution was ratified before the Pendleton Civil Service Act was passed in the 1880s, then anybody could be hired or fired by the president, any federal employee. And so there really wasn't a civil service at the time the Constitution was written. Alexander Hamilton said that the executive branch needs energy. So really what you've got with the bureaucracy is these are people who they cannot be fired by the president unless they have done something wrong, okay? Which, of course, you can see that in the news where they're, if there's somebody who, people in the bureaucracy can, use the power that they have to kind of bend the way that the laws are being enforced. And some of them may work against the wishes of the governor or the president. Now, when we're talking about iron triangles, we're talking about, when basically we're talking about this relationship between interest groups and people who are in elected office. Okay, so when we look at iron triangles, which Hip Hughes, my friend Hip Hughes, has a great video on this. So, I would encourage you to watch Hip Hughes' video on iron triangles, but I'm also going to put this up on the screen right now so that we can see how this is going. But yeah, I would say that Federalist 70 may be against the bureaucracy because that undermines the president's control of the executive branch. And so what you see here is that an interest group is going to lobby Congress. They're going to give like electoral support in the form of, campaign contributions and the like. So let's think about pharmaceuticals. Okay, so for example, the pharmaceutical industry is supporting people for Congress. The pharmaceutical industry is like the #1 lobbying industry that we see in our in our society today. So Congress, then what they'll do here is when Congress puts people into the bureaucracy, now they're going to give money to places where the interest group wants. Now, another thing that we can see here is that when there are appointments and stuff like that, there are things, they'll think about, does the interest group approve of this FDA director or something like that? So when we think about this, that the interest group is supporting members of Congress, and then when members of Congress are considering, the president's nomination for somebody to head the FDA, then when we're looking at that, we see that, they're going to look to the interest group, and the interest group will say that, we either want that person in there or not. So the interest group, the elected officials, and the bureaucracy are all working together here in terms of, and that's what makes this iron triangle. And typically we're going to see spending go up because of iron triangles. So that is a good question. Now, one thing that I would actually note here, and I don't think I was thinking about this just now, let's see, AP Government Course and Exam Description. Okay, let's just note here. Let me just note here, iron. Okay, one thing to note here, let me just make sure. Okay, actually, that's topic 2. Okay, that's in unit 2. So iron triangles could be there. So that is something that, that's good that we're looking at that. So that is in unit 2. I was thinking maybe that was in the unit about, about interest groups, but that's in the unit about the topic about the bureaucracy. So as far as that goes, that's just a little introduction to that. Can I go over the full faith and credit clause? I sure can, Eloise. So the full faith and credit clause basically says that states need to respect the laws of other states. All right. So basically, the full faith and credit clause. Thank you, Kate. This is so nice of you to say. The full faith and credit clause. What the full faith and credit clause says is, for example, if my, if my car is stolen and somebody drives my car into Georgia, then the state of Georgia would cooperate in bringing that, as far as that goes, would cooperate in, getting my car back to me. Okay, my buddy actually had his car stolen in Georgia, or his car got stolen from him in Georgia. He didn't arrange it, right? And so they called him and said that. Now, also, let's think about this, that if somebody has a driver's license in, for example, South Dakota, where they may be able to get their driver's license at 14 and a half, one state has to recognize another state's driver's licenses. So, if this license says, okay, this here, now there may be a few nuances there. I need to check on that. Don't y'all start driving into other states without that. But as far as that goes, for example, let me talk about my ID, for example. So if I'm driving through Tennessee and I get pulled over, that Tennessee has to recognize my South Carolina driver's license. So basically, the full faith and credit clause means that the states will honor, laws that are passed in other states. So, now, of course, there are some limits to that. So, for example, if I have a concealed carry permit in South Carolina, Illinois does not have to honor that concealed carry permit. So essentially, it's just that the states will respect each other's laws. Okay. And so, so with that, let's see here, the link to the document with the concept application. Now, I didn't have the concept application rubric per se. That doesn't have a rubric. That has the concept application doesn't have a rubric. The argument essay does. And if you Google AP Government Argument Essay, right under the College Board links, you'll see my link that's got the argument essay there. All right. So with that. Now, as far as the various forms of federalism, okay? So as far as that goes, the forms of federalism, now, of course, this is one of those things that you kind of get like the night before the exam. That can be sometimes something that that I even have to look up sometimes. And I'm just like, wait, what is that again? Because remember, federalism is the idea that the federal government, the state governments, they have their own powers. Now, remember, a delegated power, that's a power that goes to the federal government. These can be enumerated powers, powers that are specifically listed, or implied powers, powers that aren't listed, but they can kind of be assumed to be there. Okay, so that's something here. Now, as far as that goes, our main forms of federalism are dual federalism and cooperative federalism. Okay, and so dual federalism basically says this is what the states do, this is what the federal government does. Okay, and sometimes they call it layer cake federalism. You know, it's like we got this layer, this layer, this layer. Dual federalism means this is the federal government, this is the states, and they have their powers. Now, cooperative federalism says that they should cooperate more on policy. So, for example, if you want something about cooperative federalism, think about the interstate highways. Okay, so when we think about cooperative federalism, the federal government passes laws about interstate, authorizing the construction of interstate highways, and they give the money to the states, and the states actually construct those highways. So, dual federalism would be like, hey, federal government, don't tell us where to build roads in our states. And so cooperative federalism means that you can collaborate on policy issues. Okay, so that is, what they call marble cake federalism rather than layer cake federalism. So just understand that, just in case that comes up. But I think what's most important is you understand the concept of federalism. I think that is especially important to understand the concept. All right. So going from there, can I go over the concept application portion? Yeah, so Matthew, I would say for a demonstration, go to Marco Learning's YouTube channel. You'll see me work out a concept application. And this is basically just like a short answer. If you took APUSH last year, let's see. So, let me do a little poll here and see what we're dealing with. Who took APUSH last year? Okay, so who took APUSH last year? Me and not me. Okay, so let's see how many of y'all took APUSH last year. And if you took APUSH last year, there really shouldn't be a whole lot of there shouldn't be anything that should scare you or anything like that. So we've got some of you, we've got the majority of you took APUSH last year. But as far as if you're taking APUSH this year, okay, if you're taking APUSH this year, Colin, go ahead and put that, okay, because basically the concept application, think short answers on the AP US History exam that you need to give. You need to answer in complete sentences, anywhere from like 1 to 3 sentences, should be able to, do all of them. And you need to bring in a specific detail. You need to be, just don't mention something, but explain what it is. The same guidelines for AP US History, AP European History, AP World History, short answers, those are going to be the same guidelines for the AP government exam, where you're dealing with the concept application. Okay, so given that, a great many of you have done that, have taken those exams or will take them, I would not stress too much about the concept application. But I do have something on Marco Learning's YouTube channel where I'm showing you how to go through that. And so then what we want to note here is that I'm going to do a mock exam. I'm going to do that tomorrow right before the exam. I'll be broadcasting at 2 p.m. Eastern. All right. So with that, And so as far as that goes, let's I don't know if like let me just take a look here. Okay, the words sovereign immunity never appear in the course and exam description. So that's another thing. Why is sovereign immunity constitutional? You don't have to know that for the exam. All right, so now as far as that goes, it's not just necessarily like foundational. The foundational documents aren't going to directly address bureaucracy. The thing is that perhaps, it's not, I wouldn't go to foundational documents to make an argument for or against bureaucracy. And we'll see how that works. Okay. But I don't think that we're going to necessarily see, like, I don't know. That's an interesting question there. I'm trying to think of an angle they could go on the argument essay that would bring in the bureaucracy, but I'm not sure. Now, critical elections and realignment, I think that there's going to be, PK, a lot of overlap, okay, between critical elections and realignment, okay, because a critical election is something that we're going to see, in terms of that does create this. So the 1932 presidential election, let me go ahead and pull that up here. Okay, so the 1932 presidential election, I think that this is probably our single best example of a critical election / real. Now, actually, when we're looking at that, let me just note here. Okay, so critical elections and realignment are not going to be on this year's exam. Okay, so that is in Unit 5. Okay, so don't worry about sorry, sometimes I start answering questions and I realize, wait, that's not on this year's exam. So critical elections and realignment, not so much. Okay, now PK, I think that would be a great question for like an argument essay. Could the right to privacy be considered a Ninth Amendment right? Now, the thing is that certainly has been argued by some Supreme Court justices, that the Ninth Amendment, basically, when you look at this, where it says that privacy may not be mentioned in the Constitution, but at the same time, it says in the Ninth Amendment that rights that people that are declared, they're not, the Bill of Rights, the enumeration of those rights is not meant to disparage others that the people could retain. Now, another thing when you think about the right to privacy, the Fourth Amendment, protection from unreasonable searches and seizures. It is assuming as a default that you are that you have a right for your private papers and your personal items and for your home to be private unless there is a reason, a compelling reason why your home should be entered, why your things should be searched. So that's something that I think is super important there. All right. So going from that, we want to also consider the Fifth Amendment. Your Fifth Amendment right of protection from self-incrimination. Okay, so when we think about your Fifth Amendment right to be protected from self-incrimination, it implies, so that's the thing, that the right to privacy is implied in other parts of the Bill of Rights. So if I have a right to say, I plead the Fifth, I don't have to testify against myself, then the government does not have a right to make me do that. Okay, so with that, we'll go into that. Now, do we need to know economic theories? I would not put that at the top of my list, the night before the exam. All right, so the letter from Birmingham Jail, okay, so letter from Birmingham Jail is a little bit different. Now, the Declaration of Independence and the letter from a Birmingham Jail, these are, two foundational documents that are not law codes, okay? They're not law codes, and they are, not commentaries on law codes. So it's not, the Constitution, the Articles. It is not the Federalist Papers or Brutus that are giving the commentary here. Okay, so when we think about the letter from Birmingham Jail, that Martin Luther King has been, he's defending nonviolent resistance. Okay. So as far as that goes, that, when King says that the principle of justice is something that goes higher than the law. Okay. So he is defending his record of civil disobedience. Okay. So basically, he says that, I mean, generally, if we think about this, like one of the principles of American democracy is ordered liberty. Okay. So ordered liberty, which especially we're seeing here in the pandemic, that when we think about ordered liberty, that, as far as I'm saying that two foundational documents that are not law codes are not commentaries on law codes. So when it comes down to it, foundational documents, the other ones are either law codes or they're commentaries. But Martin Luther King Jr., when we think about ordered liberty, especially during the pandemic, it's like, I complain about my neighborhood pool being closed by bureaucrats, and people say, well, look, we have a pandemic. We have to give up some of our rights. But I'm like, look, you can't have ordered liberty without liberty. But then again, you can't have ordered liberty without order. So as far as that goes, that Martin Luther King was willfully violating laws. Okay. Now he wasn't doing it in a violent way, but, civil disobedience. So you think about, the young men who sat down at the lunch counter in Greensboro, North Carolina. What they were doing was violating a law. Martin Luther King would say that they were doing something in accordance with justice, that if there is an unjust law, then a citizen has an obligation to break that law, okay? Not to break it in a violent way, but civil disobedience, okay? So essentially, this is where we're getting into this idea, and it really pairs well with the Declaration of Independence, because the Declaration of Independence says, look, here are all of these injustices that King George III has rained down on us as colonies. And so therefore we are, not civilly disobedient. We are going to have an armed revolution because of all of these unjust laws and the unjust treatment we've received. Because Jefferson writes that the purpose of government, is to protect life, liberty, and the pursuit of happiness. And so when we look at these things, life, liberty, the pursuit of happiness, and that all men are created equal. And so when these principles are not being followed by law, okay, they're really good bookends here. So when the principles of the Declaration of Independence are not consistent with the law, then we have a little bit of an issue there, in some cases, a lot of an issue. And so Martin Luther King says that, yeah, you have, no obligation to follow an immoral or unjust law. So that is, again, now the only foundational document as well that comes from doesn't come from the 18th century. Okay. So the time of the American Revolution and the Constitution. What is a Bill of Attainder? A Bill of Attainder is pretty interesting here in the sense that it's basically when the legislature declares someone an outlaw, says that they are guilty, that this person has violated the law, and that person can be executed without a trial, or that person can be imprisoned or punished without a trial. So in the history of England, you can see where Parliament would pass bills of attainder, and that would basically declare someone, which a bill of attainder, the reason why bills of attainder are not constitutional is it does not give people due process. When we think about separation of powers, that that is the judiciary. Only the judiciary should be able to find someone guilty of a crime. So a bill of attainder is basically a guilty verdict that is handed down by a legislature without a trial, without due process. And that was done, quite a bit, several times in English history. And that's why the Constitution prohibited. All right. So as far as that goes, okay, so we're thinking about Mcculloch versus Maryland. Okay, now let's talk about the Supremacy Clause. Okay, so Mcculloch versus Maryland, that is a Supremacy Clause document, or a Supremacy Clause case, which basically federal laws, if they're made in pursuance with the Constitution, they are the supreme law of the land. The Constitution and laws made by the federal government that are in pursuance thereof. It's the supreme law of the land. Now, the thing is, if the federal government makes a law so if Congress passed a law that is not constitutional, that is not the supreme law of the land. So what we want to understand is our counterpoint to Mcculloch is Lopez, okay, where the Congress is like, oh, guns pass over state lines, so that's interstate commerce. So now we can have a Gun-Free Schools Act and say that it's a federal crime now to have a gun near a school. Supreme Court's like, chill, okay? No, that's not how it works. That's not how the Commerce Clause works. Now, Lopez was part of the Rehnquist Court's doctrine of New Federalism, where they are, the Rehnquist Court has this doctrine of New Federalism where they are devolving some powers to the states. Okay, so you see, Lopez is indicative of that. So whereas the Marshall Court tended to give the federal government more implied powers, what we see with Lopez is the Supreme Court, after kind of loosening their view of the Commerce Clause, the Rehnquist Court tightens that up and says that no, the state of Texas will prosecute Lopez for having a gun in a school zone. Okay, so not the federal government. So understand that the Supremacy Clause, there is still that other side of that it does not give the federal government the right to pass any law they want. So with that, you see that, that with Mcculloch, what we see are two things. First of all, the Marshall Court rules that the bank is constitutional, even though the bank's never mentioned in the Constitution, and then goes into, basically, since it's constitutional, it falls under the Supremacy Clause, and the states can't mess with it. All right. So with that, a summary of Federalist 51. Okay. So as far as that goes, let's think about this. Federalist 10, large republics and factions. Okay. When we look at Federalist 10, Madison's thesis here is that in a large republic, a single faction can't take over. Now, he is answering Brutus, okay? Brutus, who said that you can only have small republics. Look what happened to the Romans. As they grew, they lost their republic. If we consolidate our governments into one government, as Brutus saw the Constitution doing, then we will, we're just not going to be able to, to have a Republican form of government. Madison says, look, factions can take over states. In a large republic, so states are small republics, it's easy for a single faction to take over. In a large republic, it's hard. So think about gun laws, for example, like when you think about things like gun laws, that a local community or a state has an easy time making gun laws. A faction can take over. Look at Virginia earlier this year, that you had a big, big armed protest a couple of months ago over several laws that were being passed by the Virginia legislature. Now, when the Democratic Party has control of the legislature and they have the majority, they've got a governor who will sign it. They can get laws passed. Now, look at the federal government. It's very difficult to get any kind of gun laws passed by the federal government because in a large republic, it's harder for one faction to gain prominence. So that's Federalist 10. Federalist 51 is that's explaining how the three branches of government works. Also Madison, 10 and 51 are Madison. Federalist 51 is going into, how all of the checks and balances work. Basically, what Madison's arguing, Brutus was concerned because this new government was given more power. And if a government has more power, it'll become a tyranny. Madison's also answering Brutus, saying that, no, like this government may have more power, but we've got so many checks and balances. The powers are separated, and we put in all these checks. Madison writes in Federalist 51, ambition must be made to counteract ambition. And so what happens here is he says, look, the president's going to be power hungry, but Congress is also power hungry. The judiciary is power hungry. Basically, we've got like three lions that are fighting over one piece of meat, and nobody's going to be able to take over because every branch is going to be jealous of their power. Now, another thing about Federalist 51 that Madison is writing about is how the states will also check. So that's another part of Federalist 51, how you have not only the horizontal checks and balances, legislative, executive, judicial, but you have the vertical checks and balances that the states will fight back when their powers are violated. So Madison, remember that the overall argument of the Federalist Papers in general is to argue that the Constitution is both federal and Republican, small r, okay? Federal and Republican, that it preserves the federal form of government, and that it leaves powers to the states, and it is a Republican form of government, that it ultimately answers to the people. Now, Federalist 70, that's Alexander Hamilton being Hamilton. He's like, look, we need a unitary executive is a good thing because the executive branch needs energy. The executive branch doesn't need debate. The executive branch needs energy. So we need the executive branch not to have checks within it. We need one person in charge because that branch needs energy. Okay. So Federalist 10, factions, large republics. Okay. Then we see Federalist 51, separation of powers, checks and balances. Federalist 70, we need a unitary executive because the executive branch requires energy in order to be effective. Now, then Hamilton's still being Hamilton in Federalist 78, but he's like, nah, y'all don't have to worry about the judiciary. Brutus, number one, okay, Brutus wrote that the federal judiciary is going to eclipse the dignity of the state courts, like that they will eclipse the dignity of the state courts. And so, Hamilton says, nah, it's going to be the least dangerous branch. That is where Hamilton calls the judiciary the least dangerous branch. You'll barely even know it's there. And then we see where, not only in terms of the least dangerous branch, but also when we're looking at an independent judiciary. So Federalist 78, least dangerous, and it's okay that it's independent. So that was one thing that when you look at the judiciary, it is the least democratic part of our government. It is insulated from the people, insulated from the political process. There is no way for the people to remove people and, from the judiciary, from the people at large, like they can with the president and with the Congress. And Hamilton's like, look, it's good that they're independent because we don't want them getting political. Yeah, you think about now, I mean, read Brutus number one, not like just look at Brutus number one and you see like, wow, this guy knew so much about the way that our government was going to develop and evolve. Okay. So as far as that goes, we see that. So watch this video. Okay. So James Madison equals Bay. Fat Zach says. All right. And ladies and gentlemen, remember that on my Instagram account, I have just posted something from my friends at Marco Learning. If anybody follows me on Instagram, I'll do a shout out. I'm going to wrap this up in just a little bit. Okay, so, but we're going to be back at 2:00 p.m. Eastern tomorrow. Tell all your friends. But on Instagram, I put this timing guide here for the AP government exam, okay, which you can't see it. Well, actually you can a little bit, but go to @TomRicci on Instagram. And while you're at it, follow @Marco Learning. Now, remember this link that I'm sharing with y'all. These are free practice tests. I love you too, Brian. And free practice tests that we've got, at the Marco Learning website. You can download a free practice test for AP government and for 9 other subjects. Okay, so free practice test, so that you can get a free practice test at marcolearning.com. Okay, so make sure that you're ready for that we've got this free practice test. This is, you just go to marcolearning.com. You can follow that link, or you can go to free resources and practice test, and that would be a good thing for you to do. I would read a foundational document or two. Okay, I would actually open it up and read it. Here's one thing. I would not just, I would not only tonight subscribe to Marco Learning's YouTube channel. Okay, let's see if anybody is subscribed. John's got a lot of great videos that are available here. Good. We've had a few subscribers, so y'all keep doing that. But I would read a couple foundational documents. I would actually print it out and I would read it tonight. maybe it'll help you fall asleep. Okay, especially if you read Madison. Hamilton's actually kind of interesting, but Federalist 51, if you're thinking like, hey, I need to go to sleep tonight, so just get my mind off exams tomorrow, read Federalist 51 and just see how long you last till you fall asleep. And so the thing is, I think that looking at a few foundational documents, because we know that there will be foundational documents on the exam. So the most important thing that you can do tonight is look at foundational documents. Okay, that's going to be your lifeline. And I wouldn't just look at summaries at this. I mean, I would pick a couple of them to actually read and familiarize myself there. Dragon Energy, there you go. Yeah, Kanye wants you to get a 5. Some of y'all been with me for a while, and I sure appreciate that. Let me just say that, wow, that is just so nice for y'all to still be around. Yeah, Brutus #1. I would read Brutus #1 and perhaps Federalist 10, or I would read Brutus #1 and one of the Federalist papers tonight, so that you have both sides of this. Okay, and so going with that, tomorrow again I will be going live at 2 p.m. Eastern, and I want to make sure that y'all are joining me. Hope to see y'all there. And do we have some new followers here? We do have a few. Thank you, Noel, for following. Ellie. And we've got, yeah, so Faith Nicole, thanks for your comment. I am certainly glad to help. And let's see, actually, you know what, Faith, you've been coming to these things for quite a while. And so thank you so much for your support. And Swisher10940. Thank y'all so much. Feel free to keep, y'all definitely share this Marco Learning Timing Guide with your friends. Okay, this is something that is going to be good. It goes in and you kind of know, okay, this is what I've got to do. And so if you get that, you shouldn't be in a position to I don't know what I was saying. Somebody asked me on Instagram, odds of servers crashing. Okay, so we're going to find that tomorrow. Now y'all are actually going to be the guinea pigs tomorrow. Alexis Rollins, thank you for the follow. Roll Tide. Okay, gosh, this Clemson fan just got an Alabama follower. Thank you for that. I always love my friends in Alabama. So yes, if Harambe wills it, you will pass your exam tomorrow. If Harambe wills for the servers not to crash, okay, then the servers won't crash. But y'all are actually you are going into the breach, like you are like the first people that are basically going over the top and trying something tomorrow that is unprecedented. Okay, so that's something that that is really powerful here tomorrow. So yeah, odds of servers crashing tomorrow, I don't know. Hopefully everything will go well, but y'all are going to be the ones. You're the first major exam that is going to be taken. All right, we got an LSU fan, which is my native state. So I'm glad that they did well. So with that, ladies and gentlemen, I'll be back tomorrow at 2 p.m. Eastern, and I'm looking forward to bringing y'all through the exam. Remember, go to MarcoLearning.com for a free practice test, and go to Marco Learning's YouTube channel to see some videos that I've made over the past few weeks about, how to tackle the AP government exam. So 2 o'clock tomorrow, looking forward to it. It is always a pleasure, ladies and gentlemen.